What money damages are available in a wrongful death claim? In Washington, there are 4 interrelated statutes which govern calculation of recoverable damages in a wrongful death claim. I want to begin by saying that none of those statutes can ever replace the husband, wife, parent, or child who was lost, ever. But a successful claim can help the survivors in many ways. An attorney can coordinate with the criminal prosecution of the party at fault. An attorney can help arrange for grief counseling. An attorney can help care with the client. But of course, our most important form of support for grieving families is in securing monetary compensation for their loss. Money can't relieve the grief, but it can help to relieve the financial burdens. So, to answer your question, there are 4 statutes. The first statute governs loss of a minor. If the person who died was a minor, that is under 18, damages are defined to include, quote, loss of love and companionship of the child and for injury to or destruction of the parent-child relationship in such amount as under all the circumstances of the case may be just, unquote. Now that's broad language. And courts have interpreted it to include parental grief, mental anguish, and suffering. Now, significantly, computation of damages is not limited to the time the child is under 18, because these losses continue forever. A second statute also allows damages to be recovered for the loss of a child or an adult on behalf of the wife, husband, child, or children of the deceased. Adults who are single and without children don't qualify. For people who die with a surviving spouse or child, quote, the jury may give such damages as, under all circumstances of the case, may to them be just, unquote. So pain and suffering in anticipation of death is recoverable under this statute. So whether an adult who dies has dependents and therefore qualifies for these recoveries dramatically affects verdicts and settlements in death claims. A third statute allows recovery for all people, even if they were unmarried and without dependents. The recovery is to their estate and includes the present value of their future net earnings had they lived a normal life expectancy. That is, their future income minus their future spending, or what lawyers call their net accumulations. The estate must prove these losses through the calculation of an economist. And there is a fourth statute, which allows recovery for medical, hospital, medication, funeral, and related expenses. So those are the 4 statutes. And there are 2 ways that we estimate the monetary settlement value of a claim. We use a combination of the 2. First, to find a total claim value, you add up the amounts you're entitled to for property damage, medical expenses, funeral expenses, the present value of future lost net accumulations, and the general damages allowed for loss of a child, spouse, or parent. But since general damages are difficult to predict, we use a second method to estimate a monetary settlement value. We review state, regional, and national publications and computerized databases to find similar cases in similar situations and similar liability patterns to develop a statistical analysis of value. We then review those estimates in light of our 35 years' experience in trying and settling wrongful death cases all across the state of Washington. We've recovered record verdicts on wrongful death cases in several jurisdictions in both western and eastern Washington, so we know what is possible. I hope that answers your question in general. If you want an estimate on how a particular wrongful death case is valued, our website has a free claim evaluation form. If you fill that out, we'll get back to you by noon of the next business day. And we try to answer 2 questions. Do I have a valid case, and what is it likely worth? Thank you.